SJC-12630, Commonwealth v. Stanley Jeannis.
Mr. McLean.
Good morning, Mr. Chief Justice. May it please the court, Ian McLean on behalf of the Commonwealth. Your Honors, this court should affirm the denial of the suppression motion for two reasons. First, the strip search that did occur was supported by probable cause. And second, neither the search nor the seizure rose to the level of a manual body cavity search, as there was no probing or touching of the anal cavity itself.
Well, the first issue is not contested, and as to the second issue, where is the factual support for Judge Trochka's finding? Well, not just his finding, his ruling at the end of the decision that this never moved into a body cavity search.
Yes, Your Honor. The factual finding is protruding from the defendant's buttocks.
What does that mean? What does that mean?
Your Honor, the word buttocks means an exterior portion of the human body. So that's a factual finding indicating that this item was on the exterior of the human body. So there are three different words here that are not interchangeable, Your Honor. Buttocks, anus, and rectum. They all refer
About
to...
protruding?
Excuse me?
What about the word protruding?
Yes, Your Honor. A portion of the baggie was coming out of the space between the two buttocks. The intergluteal cleft is the technical medical term for that space. So as to where the factual support for that finding was in the record, first I would point, Your Honors, to the fact that both officers that testified, Lieutenant Callahan and Officer Singer, neither of them ever used the word anus or rectum. Lieutenant Callahan testified the baggie was protruding a little bit from the buttocks area. That's it.
Okay. So I don't know what that means, though, and protruding from the buttocks area. Does that mean that it was in the body cavity or not in the body cavity? And this is a warrantless search with heightened probable cause. Isn't it the Commonwealth's burden to have in the record something that we can infer that the plastic bag was within the body cavity? Was not within the body cavity?
There are plenty of places where that is found, Your Honor, but first off, I would say that this is a warrantless search, but as in any search case, the defendant bears the initial burden of establishing a search in the constitutional sense occurred, meaning a government intrusion upon a place where he had a reasonable expectation of privacy. So the initial burden is still with the defendant to establish the place. So here that was contested. Defendant took the stand and he testified in my rectum twice. Judge Trochka heard that testimony. Officer Callahan took the stand and said protruding from the buttocks. Officer Singer took the stand and he said, used the term butt crack 3 times. You know what he was referring to was the space between the intergluteal cleft, because the first time that he said...
The intergluteal cleft wasn't mentioned once during the hearing.
No, Your Honor, it was not. It's the medical term for the space between the two buttocks.
Can I ask how big is this? Do we know how big this baggie is? From what I understand, this is a 275-pound man, right?
Correct, Your Honor. It's a 6'2", 275-pound man that Judge Trochka saw in the courtroom.
And how big is the plastic bag? Do we have pictures of the baggie? Is it I mean, I have baggies in my house. I got ones that are this big. I got ones that are this big. Do we have any sense of how big the bag is?
Yes, Your Honor. It's at Commonwealth Appendix 30 is the picture. There you can see the 2 individual baggies, one of heroin and one of cocaine, and then the baggie they were contained in immediately to the left of the cell phone.
And just rather than me look, how big do you have a sense of the size of these bags?
Yes, Your Honor. It's smaller than a sandwich baggie. So we're talking about a 275-pound defendant, 6'2". So imagine take an inch off of my height at 85 pounds. Judge Trochka saw this individual in the courtroom, saw him walk from counsel table to the witness stand, testify, and then return. So Judge Trochka had eyeballs on the size of this man himself. He also had one of the officers pointing that fact out to him in the testimony, specifically referencing the size of the defendant, voluminous buttocks, and unsure what exactly he could be storing in that significant amount of space.
Can I barrel? So it's sticking out now, and the case I'm most familiar with is Vic, which seems to be awfully close, if not exactly the same as this. But they're able to, in Vic, they're able to flick it out. Here, they do something with his buttocks, right? They push something aside according to the testimony, or is that not correct?
There's no factual finding to that effect, Your Honor. The factual finding is merely that the defendant removed it and Officer Singer placed his hand over the defendants for officer safety because they did not know what was contained in the baggie. Could have potentially been a weapon.
Well, he removed it because the police officer said, if you don't remove it, I'm going to.
Yes, Your
So
Honor.
I'm
that's-
not sure that helps.
Yes, Your Honor. But as to the
Keep guns in baggies ordinarily?
not necessarily, Your Honor, but there's certainly a plethora of other weapons that could have been contained within the baggie, a razor blade,
Inside your buttocks?
In your
Any sort-
buttocks?
That's unusual, isn't it?
well, Your Honor, it would be unusual for me, but I'm not a person that was going into custody somewhere trying to secret something from the officers finding it. So there's a factual finding that the officers were concerned that it was a weapon and were concerned for their safety.
You
So
you don't need that to win, do you?
No, Your Honor, we do not need that to win.
No.
That seems like a ridiculous
So,
argument.
so what you have to show is that the bag was completely outside of the body cavity, right?
No.
No, not necessarily, Your Honor. I mean, that was the factual situation in Vic, but it's less clear in Thomas, Your Honor. And I would point you to the exact language in Thomas was the first bag fell by itself independent as the individual was removing his final layer of clothing. He was instructed to do a squat. The second bag fell. A third bag was still visible to the officer's naked eye.
Different, there was no touching of anything in the body cavity.
Well, the actual factual finding was the officer observed yet another plastic bag in the area between the defendant's buttocks and removed it. So the officer himself reached in and removed the bag. So, and that was still found to be a strip search, not a manual body cavity search. So here,
No body cavity?
excuse me, Your
What
Honor?
is it, what is body cavity? How do you define a body cavity?
Here it would be the rectum, Your Honor. So it's
How do we know that?
well, because a rectum is an interior cavity of the human body. The anus is the,
Interior cavity.
yes, an interior cavity. So here, the actions that the officers took did not intrude upon the interior cavity of the human body. Judge Chachka used the word buttocks. Judge Chachka is an intelligent man and knows what the word buttocks means and knows the difference between buttocks, anus, and rectum. They're discrete portions of human anatomy. Finding one is necessarily finding not the other. To draw a very, very simple comparison, if say the color of a car was a relevant factual finding, if one witness took the stand and said the car was red, second witness took the stand and said the car was blue, and the judge found as fact the car was red. Inherent in that factual finding is that the car was not blue.
Did you say that it doesn't have to be, it can be partially in the body cavity and still be a strip search?
Yes, Your Honor, the test for whether something qualifies as a manual body cavity search is whether it's touching or probing of the anal cavity itself. So if the officer entered the anal cavity and conducted a touching or probing of the cavity, then it would qualify as a manual body cavity search. With an item that is maybe partially contained within the body, what we're talking about then is merely extraction. But that's not even the factual situation here, so we don't even need to get to that question here.
But that's because the defendant removed it himself.
Well,
I mean, there's no
Your Honor.
finding about how far in the baggie was, right?
I would disagree with that, Your Honor. I would say inherent in the finding that it was between the buttocks is the finding that it is not in the anus or the rectum. It's the situation where the judge says, I find as fact the car was red. Inherent in that factual finding is the inverse. The car was not blue, the car was not purple. So here the judge found protruding from the buttocks, not protruding from the anus or rectum, protruding from the buttocks.
Right, so given you that point, there has to be something that, in the motion to suppress here, and something in the evidence that allowed for that. Officer Singer said he could see a piece of plastic bag coming out of the defendant's butt crack. The defendant spread one cheek and we reached in and retrieved it, and he retrieved it from inside his butt. The defendant helped Officer Singer to take the drugs out of his butt. That's the testimony. And if it was from the buttocks, you're right. The question is whether there's anything in the record that allows for that finding that Judge Tochka made.
Yes, Your
The
Honor.
buttocks point, and let's assume that's correct.
Yes, Your Honor. I would start with the fact that the defendant took the stand and testified and claimed it was in his rectum twice. And Judge Chachka did not find that. Lieutenant Callahan testified buttocks area, and Officer Singer testified butt crack 3 times. You know what he meant by the term butt crack based on the context from the first time he used that term. The context was the defendant had pulled the hemline of his underwear down and the baggie was visible. So there's no way that he could have seen the anus or the rectum at that time. So when he says butt cracked, what he's referring to is the space between the buttocks. The intergluteal cleft is the technical medical term for that space. That is part of the basis. So Judge Chachka heard one witness say X, heard another witness say Y, and he found Y. Now, what else did Judge Chachka have in front of him? He saw the defendant himself, saw the voluminous size of the man. He saw the picture at Commonwealth Appendix 30 that you have, the minuscule size of the baggie. And the size of the defendant and the voluminous nature of the buttocks was further brought to his attention from the testimony of Lieutenant Callahan. And I point, Your Honors, to Commonwealth Appendix 76, where he indicated, Mr. Jeannis is a large man, and I wasn't sure what he could have secreted in that area. So those things were all in front of Judge Chachka. He made a credibility determination based on the witnesses that testified before him and his observations of the defendant. He found X, buttocks. He did not find Y, rectum or anus, even though he was invited to do so by Mr. Jeannis, who took the stand. So he discredited Mr. Jeannis's testimony, credited the officer's testimony. What he found here was the baggie was exterior of the human body, which puts us squarely within the realm of Vic, where the...
We have a practical problem here. A plastic bag is protruding from someone's butt. You probably can't know whether or not it is within the realm of the rectum, unless you were to do what would itself be a visual body cavity search. So what do you do? Put aside, I mean, I know you're trying to say there are clear lines. This was never within the area, no part of the plastic bag was within the area of the rectum. But let's assume you don't know that. What is the appropriate course of action for the police to take when there is a plastic bag protruding from the butt and the police may not know whether it is partially within the rectum or not?
Well, I have two things to say in response to that, Your Honor. The first is that this court has repeatedly recognized that when executing a search, it must still be executed in a reasonable manner here. And one of the factors to consider there is to try to use the least intrusive means possible. And I'd point you to Morales, indicating that that's the way we would like officers to proceed. Everything the officers did here was reasonable. They saw a baggie protruding from the buttocks, and they said, extract that for us. So they afforded him an opportunity to do so, which is something that was commented upon favorably by this court in Morales. So yes, Your Honor, the officers would have sort of a catch-22 with their ability to determine that 100% of the baggie is exterior is in the exterior portion of the human body. How could you ever actually know that?
So what is reasonable? I mean, we allow a modest degree of force with the view that that's okay, but if we pull and it's not coming out, because it may not be a sandwich bag, but a quart bag or a gallon bag, and it could be deeper in there, we have to worry that it could be causing harm to the individual. If we were to pull it out, then that would trigger a visual body cavity search?
Yes, Your Honor. As with any seizure, it still has to be conducted in a reasonable fashion. So here, by saying remove that, placing your hand over the defendant's hand as he removed it, there are no factual findings about force being applied or pain or any of the things that would indicate the baggie was inside the anus or rectum or was increasing in size as it was being extracted. There are no factual findings to that effect.
How about weren't there findings that he was sort of walking stiffly and sort of sitting over to one side? That doesn't indicate any kind of discomfort or anything like that?
No, Your Honor. The factual findings were during the booking process, he was sitting oddly askew to one side as he was seated, sitting on one cheek of his buttocks. And then as he walked down the hall to being brought to a toilet, because he indicated he may have to vomit, despite not being shackled, he was moving slowly and rigidly and clenching his buttocks as he walked. Those are indicative of someone trying to retain the item between their buttocks. So those were the factual findings that were made. There were no factual findings made that the baggie was inside the anus or rectum or that there was any force used to retrieve the item.
Even if it is slightly in the rectum, isn't the issue whether you are inspecting, you're looking inside the body cavity, or you're manipulating the body cavity? Isn't that what our cases have talked about in terms of the dividing line?
Yes, Your Honor, that is the difference. The Thomas case points out that it is touching or probing of the cavity itself. That's what it takes to qualify as a manual body cavity search. Short of that, it would be a visual cavity search, which requires only probable cause and doesn't carry...
But again, there's a difference, right, between a visual... We're looking at the man's buttocks with the plastic hanging out is different from inspecting his anus, because we're concerned about inspections of anus and vagina areas because of all the invasion of privacy that entails, right?
Absolutely, Your Honor. Absolutely, Your Honor.
There are lines there. The fact that it enters the rectum barely, or even some, isn't the issue we're focused on, is it, as a legal matter?
No, it's not, Your Honor, because even if a tiny portion of the baggie was on the interior of the body, that still doesn't make it a manual body cavity search because the officers did not engage in an insertion, touching, or probing of the anal cavity. The officers did not violate the integrity of the human body.
But if the officers, if it was inside the body cavity, and the officers tell the defendant to remove it from a body cavity, you think under Thomas that doesn't constitute a body cavity search?
Your Honor, I can see that my time has expired. May I respond?
You may answer.
No, Your Honor, it does not, because it wouldn't involve the officers entering the human body and touching or probing inside the human body.
So that could, so anytime an officer says, as it happened here, you take it out or I take it out, and the defendant takes it out, that by definition, that's not a body cavity search?
That is correct, Your Honor. However, as with any seizure, it still has to be conducted in a reasonable manner, and that's how we would.
Oh, I understand. We're just looking at whether we need to have a warrant that actually comes from a judge based on a heightened standard.
And no, Your Honor, because the officers did not violate the integrity of the human body here. There was no touching or probing of the anal cavity itself. Therefore, this situation stayed within the realm of a strip search. There are no further questions?
Okay, thank you. Ms. White?
Good morning, may it please the court. I'm Jane White. I represent Mr. Jeannis in this case. I would like to first contest my brother's reference to that there was no search here, there was no seizure, and that the defendant had the burden of showing that there was a search. I think that there can be absolutely no question that examining someone's bare bottom is a search. Now, we get to whether or not a warrant was required, but certainly the burden, there's a search here, there's a seizure here, and when there's no warrant, the burden is on the Commonwealth to show that there was an exception to the warrant. This is very important, I would say crucial, because what occurred in the appeals court when it reversed the denial of suppression was not a matter of taking someone's credibility over another. It was not finding a subsidiary fact in disregard of the motion judges. It was none of those things. It was the appeals court recognized that there was an error of law in the disposition of the burden of proof here, and the ultimate finding is of constitutional significance, whether the Commonwealth proved by evidence.
Isn't the finding, the buttocks finding, I read the testimony, the buttocks finding, especially when the defendant is making all kinds of arguments that they're probing his anal, his rectum, the judge makes a finding consistent with what the officers are saying, which is it's pulled out of his buttocks, it's sticking out of his buttocks.
It's sticking
that's
out of his buttocks, but that says nothing about where the rest of the bag is. And this is crucial.
Well, but hold it, but the question is, are you manipulating the body cavity or are you looking into the body cavity, right? I understand, it's not the same thing. We have a bunch of cases where they're hiding drugs in your buttocks is not the most uncommon thing. We have a bunch of cases out there where officers are allowed to go like this and pull it out.
And as to those cases, and as to Vic in particular, which I happen to have here.
No, I'm quite familiar with
the
Vic.
testimony, I realize that. The testimony, and I quote from the opinion here, Green's testimony, credited by the motion judge, the bag was in the cleft of the defendant's buttocks and not lodged in the rectum. Now, there are cases, and they're cited in my brief, and these are the distinguishing feature. When there is testimony that it does not intrude, and when I think Justice Gantz asked during my brother's...
Can I probe you on that point?
Yes.
So there are cases that make that distinction, that it's not... I understand the appeals court adds a little language to that effect, but the cases, really? The cases say that it's not in something as opposed to... Which cases do that?
They're cited in my principal brief from pages 24 to 26. And in fact, all of the cases in this Commonwealth make a point of saying that there was evidence to show that it did not intrude into the cavity. And that is
That
just
that the baggie didn't intrude, or that the officers didn't
the
intrude?
baggie.
Which cases? Give me cites on that.
The one of the ones that was handed to the judge is United States versus Falks, 804 Fed 3rd 954.
Sorry, go ahead. 80 what? 80 what?
804 Federal 3rd 954. That's a Ninth Circuit case in 2015. That's cited at pages 23, 24. There's also State versus Barnes, an Arizona case. An officer must secure a warrant to remove items partially protruding from an arrestee's rectum. People versus Hall, it's a New York case of 2008. I won't keep on giving you cites, they're here in my brief.
Well, let's just assume, though, for the sake of argument, since it's not the United States Supreme Court, that there's no supremacy argument, and that if the bag is protruding somewhat
Yes,
from the rectum or anus, and not just
from
in
the
buttocks.
buttocks.
So just assume that.
Okay.
So my last question that I asked the district attorney, if the police officer doesn't touch or probe the body cavity itself, but says to the person, okay, you reach in and take that out, or I'm going to, is that or is that not a body cavity search?
That's a body cavity search, and the authorities for that are in my brief also, 37 through 39. When an officer in any context says, you do it or I'll do it for you, that is an order. And there's not really any disobeying it, and it's on the police officer and not on the defendant.
So I'm trying to figure out the line here. So if it is not within the rectum, it is a visual body cavity search, and you can do probable cause without a warrant. If it, in your view, if any part of the bag is within the rectum?
Yes, and I
But
know I've
that
cited
goes back to my earlier question is,
as to how to
were you supposed to
proceed.
know that? You see a plastic bag hanging out of someone's butt, and you may not know how large the bag is or how far in it is, so what are you supposed to do?
Well, Falks, which is cited extensively in my brief, talks about that. But you ask such a question to my brother, and I do have an answer to that, and it was not what was followed here. If there's no touching or probing of the body cavity, the officer could say, spread your buttocks and visually inspect. And that is, I suggest to the court, exactly what the testimony has been in other cases in this Commonwealth. When the officer testifies, gives evidence that he ascertained that nothing was inside the cavity, that's exactly the kind of testimony there would have been. Now, there are cases as well, and Vic is one of those, not the only one. But when there's testimony that is not so direct and saying, I looked and I saw that it wasn't in, but an inference that meets the Commonwealth's burden is if when he spreads the cheeks, it falls out. When he takes off his pants, it falls out. When he spreads his cheeks and it still doesn't fall out, a flick will do it, because those things are targeted precisely at whether any portion of it is beyond the anal sphincter, frankly.
What do we do with the testimony from Officer Singer that the defendant spread one cheek, and even assume that was at the request of the police officers? We reached in and retrieved it from inside his butt. I guess your point would be that it's the Commonwealth's burden to say what inside his butt means.
Precisely, Your Honor. It's not difficult. I would suggest if the Commonwealth had been more cognizant of what the law is on this, that it might have elicited testimony. The Commonwealth did not elicit that testimony, and when in fact the judge tried to elicit it himself, questioning the witness still didn't give the testimony. And I cannot stress enough, this is not a question of relative credibility. Nothing done by the appeals court reversed any credibility finding. Instead, when you're talking about an ultimate finding of constitutional significance as to whether or not the Commonwealth proved that there was no cavity search, you have to define cavity search. If the motion judge did not evince or apply an awareness of what a cavity search is, then his finding that it didn't cross the line is meaningless. This is precisely what an appellate court exists for, to find out if there was sufficient evidence to justify a purported finding of fact on the dispositive
But
issue
the
here.
Commonwealth says that Judge Tashka made that finding by not crediting the defendant's testimony or the medical records.
But disbelief of those things, and I say this in my brief, is not proof to the contrary. You don't have to believe the defendant's testimony. You don't have to believe what the police said.
Absolutely true. But that's true. But what the Commonwealth is saying is that he heard that testimony, didn't credit it, and then used the word buttocks, not anything that suggests anus, rectum, or a body cavity search.
But
That's their argument.
But my point is it's this court's obligation to look at the evidence introduced here to support that finding. And there's nothing here in the testimony of the officer which would allow a fact finder to say no part of this stuff was within the anal cavity.
He's 275 pounds, very large. They refer to the hem and the cleft area that they're able to see just from the underwear going down, and that it's a small bag. Why wouldn't that be enough of an inference in the light most favorable to the Commonwealth?
Well, for several reasons. That's not something that this court or any attorney can take judicial notice of in terms of the configuration of any individual's body. Even if he is a large person, a particular part of his body may not be as large. And this was never argued to the motion judge. In fact, where the Commonwealth put this size in was to say how threatening it was to the officers. Although there were 4 of them and he was handcuffed with his hands behind his back. It was not argued or even suggested that you could make an inference from the size of the guy that nothing could have been inside the body cavity. The Commonwealth first posited that argument in the appeals court, not in a brief, but an oral argument in the appeals court. And it was met with the observation that I think we'd need to have some expert testimony on that kind of thing. And I would suggest that is in fact
Expert testimony
true.
on how large somebody is and how, I mean, he was present at the motion, the defendant was present at the motion to suppress, right? So the motion judge is actually looking at him.
Well, yes, and I don't quibble with that. But that doesn't say anything about,
And
this is
we
getting
need
very
expert
graphic.
testimony to discuss how large someone's rear end is? I'm just confused
Well,
by
if
that.
you're talking about what the inference that is required to be shown by the Commonwealth with the burden of proof for an unwarranted search, you have to know a little bit more than the fellow's big.
So
And in
Richard,
fact,
can I ask as a practical matter how this is going to work in your world? So we've got a defendant in a holding cell with almost, I mean, I think probable cause to believe there are drugs sticking out of, in a bag in his rear end. While we do this warrant, what are we doing with this defendant? We're keeping him under observation. I'm just trying to understand how it will work in the real world in your view.
well, as it happens, the testimony of all of the officers was that they had already called the ambulance to transport him to the hospital.
But they can't take it out at the hospital either, can they?
With a warrant, they can.
Okay, but they still have to get a warrant.
It's always difficult to get a warrant,
No, I
always
understand.
more difficult than a warrantless
I
search.
understand. I'm just trying to say, okay, we've got a defendant with almost certainly drugs in his rear end. More than probable, highly likely. It's sticking out so that it's easily removable by him or them. He's put it in there. So that means it's accessible. How are we dealing with this while we wait with the warrant? We keeping him under observation? We can't take him to the
But
hospital.
let's get to the easily accessible. He has his hands handcuffed behind his back.
Well, we can't take the handcuffs off, obviously, right?
Can't take them off. He's
Right.
under observation.
And
In
his hands are
cases-
handcuffed behind his back?
I thought
That's
only
the-
one hand was handcuffed.
The
No?
testimony of Officer Singer was that they were handcuffed behind his back from the time he was in until the time he was out. Lieutenant Callahan testified that one hand was handcuffed to Singer and the other hand was immobilized in a lock by Callahan.
So how did he help get it out?
Good question. With his hands handcuffed behind his back.
So what about Officer, in the light administrative of the Commonwealth, Officer Singer, he could see a piece of the plastic bag coming out of the defendant's butt crack, which according to the Commonwealth, well, that clearly means buttocks, which means that it's not in a body cavity, in conjunction with the judge not crediting the defendant. Is that enough for Judge Tochka's ultimate legal conclusion?
No, Your Honor, and this is why. There's ample testimony to support a finding that a piece of plastic protruded from the buttocks. The defendant does not contest that. That was a finding of fact. But that says nothing about where the rest of the plastic bags were. And here we're talking about a plastic bag that had two other plastic bags in it, one of which had 15 twists of a powder. The other one had 13 twists of a powder. They were put each in separate bags into the larger bag, and that was what was retrieved.
Do we have dimensions on this?
I'm sorry?
Do we have dimensions on the larger plastic bag?
I do not have it, and in fact, I would like to check what my brother says about those dimensions. I have checked the exhibits in the Superior Court, and I don't believe there were any plastic bags because the drugs are ordinarily given back to the police. I don't have them. I know there's a photo of the evidence, which is in the appendix of my brother's brief. I don't know if there's a scale about that or anything. I don't know.
So, I mean, I understand that the Commonwealth bears the burden of proving that it was appropriate for it to be a warrantless search. But the purpose of the warrant with regard to a manual body cavity search is to protect the defendant both from extraordinary intrusion into a body cavity and arguably to prevent the person from physical harm. But if a mere flick is sufficient to pull something out, why must the Commonwealth do what you say they should do, which is essentially they would have to tell the person to spread his cheeks
Well, they didn't.
and carefully examine it so they could meet their burden of proving that no part of it was within the rectum?
But here, we're not talking about a flick. There's no testimony or suggestion that a flick dislodged this. I keep citing Phelps because I think it's crucially important that when you can't see all of what's there, you don't know what's in the other end of the bag. And I'm quoting from Phelps here. None of the officers could tell what, if anything, the plastic bag contained while it remained in the rectum, nor could they determine how large it was or how far it extended into the body. Despite this, and despite the fact that none of the officers had any relevant medical training, the officers did not attempt to obtain a warrant. Some medical personnel moved Phelps to a sanitary location or allow him to pass the suspected contraband naturally. Instead, there was a forcible retrieval of the bag. Now, the point here is that when you're pulling something of unknown size and configuration out, you don't know what kind of damage you're going to do. And in this case, I believe it was this case, it's certainly one in here, it says that it went from the size of a dime to the contents to the size of, and it went on up to the size of a quarter, that there were multiple items in the bag. And no, I think Rodriguez versus Furtado and all of the body cavity cases explain why that's not all right.
Can you draw reasonable inferences? I mean, if someone stuck drugs in their rear end, he's found out on the street with the drugs in his rear end, right? So he's got to be able to sell from this bag. Can you draw reasonable inferences that it's not he's got to be able to remove this himself to do his transactional work?
Well, that's not the case here, you understand.
Why not?
The case here is that he was arrested in a hotel room, that he himself was partaking of
He's
the,
arrested in default.
I'm sorry?
He's arrested on default warrants, right?
That's what he's arrested on.
Yeah,
There was a different investigation. But the evidence was that, no, he wasn't selling on the street. He was in a hotel room, and he was ingesting the drugs. And when the police knocked on the door, he was frantically putting them into the bag and shoving some off on the floor. I suppose the carpet, he ingested some. He was trying to get it out of view.
You know, one of the things that's maybe difficult about our doctrine is it seems that a visual search of a body cavity would be more intrusive than saying to somebody, you know, remove that from your behind.
That's frankly not the case law, Your Honor, as long as it does.
Just saying, it seems, I just said, I recognize in the doctrine, it just seems a little strange. Because it seems to me it would be much more intrusive to have a vaginal or anal or rectal visual search than it would be to tell somebody else to take something out from their own body cavity.
Well, if, as the doctrine shows, in order to do it yourself is the same thing as somebody else doing it. And frankly, that comes right down to a forcible penetration of a body cavity, which there are criminal statutes that prohibit that. Also, I would suggest that in this situation, and Fowlkes talks about this, as do all the cases, that there's a danger medically of hauling out something that you don't know what it is. And that's why the visual examination is not more intrusive than a forcible removal. The extraction, as Fowlkes talks about, it's something different from a search. It's a warrantless seizure. And just like searches, seizures require warrants.
Great, thank you.
Thank you.
All right.